Good evening. Hello.
Hello.
How are you, dear professor?
Fine, fine. And you?
I am fine too. Thank you for joining us. I just wrote to the group.
Uh-huh.
Participants will join. We will have 40 minutes.
I
Um,
get it. Yeah.
yeah, and I will ask you to introduce yourself because maybe someone didn't know you.
Uh-huh. Okay, okay. I will do so. Let us then wait people to join.
Welcome, Chinara. How are you? Kamar, welcome.
So how you been doing your weekend? Or you
Yeah,
are still working on Saturday?
yeah, you too, as I
Yeah.
see.
Yeah, yeah. Me too, me
So,
too.
by the way, are you working on Saturday or it's a weekend in your country?
No, it's a weekend, but basically today there was a the defense, like dissertation
Hmm.
paper.
Hmm.
So yeah, I was obliged to be present because I'm the head of that council.
Hmm.
So basically we have been working no, basically half of a day here. So no, but it happens. It's just rarely. It's not
Hmm.
often.
Yeah, okay. And thank you very much for finding your time and join our session. It's so interesting. It's about freedom of movement. And if
Yeah.
be honest, I will listen it from you for the
Mhm.
first time. So I'm so excited about this topic today.
Okay, okay, I'm glad. I just try not to be maybe, I don't know, so boring, but yeah, I will do my best.
Thank you
Maybe
very
it's
much.
not aware of all these issues that are happening.
You wore black dress today?
Black dress, right now, no, it's a top.
Ah,
Yeah,
okay. I just wondered if it's a little black dress.
no, no, no.
Uh-huh. You look
Yeah.
wonderful, by the way.
Oh, you too? Thank you,
Thank
thank
you very
you.
much.
Maybe I can start, then they just join us.
Okay, that will be
Because
perfect.
yeah, I suppose so, yeah. So they won't skip so much information to my mind. Okay, but I need to share the presentation. I've prepared one. Just a sec. Okay. Mm, from the very beginning. So you can
Mm-hmm.
see, yeah,
Yes, it's visible. Thank you very much.
visible, but it's not clickable. Just a sec. What's going on? I have to do all over again. Oh, now it's clickable.
Mhm.
Okay. So basically, let's start then.
Mhm.
So, distinguished guests, what we have here, thank you for invitation to be here today. And I want to begin with the paradox, one that I live with and quite literally every day. So I come from country where, like, since, as everyone knows, February 2022, most men between 18 and 60 cannot legally cross the international border, where curfews restrict movement after dark in cities near the front line, and where checkpoints, martial law passes, and demobilization registers governed simply act of getting from one place to another. And yet the same country like, is negotiating chapter by chapter to join a union whose founding promise is exactly opposite. So basically the right of every citizen to move, live, work, and belong anywhere within its borders without permissions, without a passport check, without asking. So that contradiction is not a footnote to my talk, as you may see on the slide today. It is the talk. And because freedom of movement is not simply a travel convenience or a line item in an accession dossier, it is, I will argue, the most honest measure we have of how much trust a political community places in its own citizens and how much trust in neighbors place in it. So for Ukraine, learning to build that trust while still at war is perhaps the hardest legal and political project of our generation. So I should say a word about why I specifically think that it's worth your 30 minutes. My own scientific research sits at the intersection of migration law and constitutional theory, and for the past several years, my research has focused on administrative legal regulation of internal displacement. Maybe you heard about such institution. The millions of Ukrainians who have not crossed the international border, but whose right to move, to register and access services and vote also has nonetheless been transformed. That exactly my research has convinced me that we in the legal environment and in government alike tend to discuss freedom of movement as it were a single self-evident concept, but it's not. It is a family of related but distinct rights, each with its own history, its own case law, and its own political weight. So understanding that family properly is, I think, a precondition for Ukraine negotiating this chapter well. So today I will do three things. First, we're gonna talk about basically what exactly. Just a sec, why exactly it disappeared? Now it's okay. You can see the next slide, yes? Yeah. So we're gonna talk about the freedom of movement actually means in EU law, where it comes from actually, what it protects and what its limits lie. Then, second, look honestly at where Ukraine stands here right now. The paradox that I just described to you, now you just maybe will be aware of what I'm gonna talk about in more detailed version. And the third, that most importantly, draw out concrete lessons. So not maybe comfortable slogans, but sometimes uncomfortable ones that Ukraine's path to membership can take from the EU's near 70-year experiment in letting people move freely. So let's start then from the part one. What does it mean? And we are all here legal scholars or legal practitioners, so everyone knows what exactly EU law and how exactly it started. So let's start with the legal architecture because I think it's the more interesting and more instructive than people assume. Freedom of movement began in 1957 in the Treaty of Rome as a narrow economic tool. So free of movement of workers on the four foundational freedoms of the common market alongside goods, services, and capital. The idea was simple. A common market needs labor to flow to where it's needed, just the capital and goods do. For decades, movement rights were tied to economic activity. And if you were not working, studying, or otherwise, like active in the whole state, you had little claim to stay there. That changed fundamentally in 1992 with the Maastricht Treaty because we know it's the exact basis how exactly EU just established as a European Union. So thanks to this treaty, and also it was the basis of creation EU citizenship as it is right now. And Article 21 of the Treaty on the Function of European Union now gives every citizen of a member state full stop regardless of economic status. So the right to move, reside freely within the territory of the member state, subject not only the conditions laid down in the treaties. That single sentence transformed free movement from a labor market mechanism into a status right, a core attribute of what it means belong to the union at all, not a privilege earned through employment. So then this directive 2004, often called like the Citizen Rights Directive, is where this becomes operational. So it codifies decades of Court of Justice case law into a tiered system. So up to 3 months, you may move with no formalities. Beyond a valid identity document, beyond 3 months, you must be a worker or a self-sufficient person, a student, or a family member of one of these. After 5 years of continuous lawful residence, you require a right of permanent residence. At that point, nearly unconditional, detachable from the reason you came into the first place. So it is a system deliberately built to reward integration over time while still protecting host states from becoming, in the directive's own language, an unreasonable burden on the social assistance system. So what I want to say here, so I want to flag something that matters enormously for Ukraine because it is often confused even by well-informed audience. Free movement of persons under EU citizenship law is legally distinct from the Schengen area abolition of internal border checks. So Schengen, basically here you may see on the slide, launched by 1995 intergovernmental agreement and later absorbed into EU law by the Amsterdam Treaty, is about not being stopped at a border. Free movement is about your right to be there once you have crossed it, to work, to access health care, to bring your family, to vote in municipal elections. Ukraine's accession conversation correctly focuses far more on the second than first, because Schengen membership is a separate, later state negotiation with its own security architecture, its own external border obligations, and its own timeline, typically years after accession itself. So it's also worth pausing on why the free movement of working was so first draft of the Treaty of Rome, and now free movement of goods and capital. And this is exactly why free movement of persons has always carried a heavier political charge than other three freedoms. So then we have to go on just to the third part, exactly the Court Balancing Act. Here I just wanted to show you case law, basically within the Court of Justice. Like you see, okay, because it's sometimes it's not clickable, and I'm just talking, and audience just do not see the same that I'm talking about, the same slide, I mean. So when we are talking about free movement was never unconditional. And the Court of Justice has spent decades drawing into boundaries case by case. So I will shortly just describe it and then just to make the conclusion, because it's also interesting to talk. And then we will go on with Ukraine paradox and these 5 lessons that I've just outlined for the audience. So the case like Zabrano expanded the rights reach into surprising territory, protecting even poorly internal situations where refusing residence to a third country national parent would deprive an EU citizen child of a genuine enjoyment of the substance of their citizenship rights. Case like Matok struck down member states' attempts to impose prior lawful residence conditions on the family members of citizens exercising free movement. And case like Dano, Arkrich, or Bidar, it's about just another kind of story. It's about holding that economically inactive citizen who move specifically in order to access another state's welfare system may lawfully be excluded from certain non-contributory benefits. So taken together, this case law shows a court constantly triangulating between generosity toward the individual and protection of the host state's fiscal and social coherence. Now, we have to move on. Yes, with the category versus conduct. Here, what I want to talk about. It's about the further layer was nothing. The court has also had to polish the boundary between genuine free movement and its abuse, so-called letterbox arrangements, marriages of convenience, and welfare shopping, because we also have such kind of violation of rights. So basically, this case law, like Akrik and later Bidar, showed the court refining over and over exactly how much residence, integration, and genuine link to the host state is required before a rights attach. Then, of course, Brexit. Everyone is just aware of what exactly it was about in 2016. It's also about that. So, expansive lesson in the EU free movement history. So, and one Ukraine should study closely is also. So, free movement of persons more than any other single EU policy was the flashpoint of the United Kingdom's departure. So no trade rule, not budget contribution. The political anxiety found deliberately in 2016 referendum campaign was overwhelmingly about people moving. It's about wages, about housing, and about who belongs. So that should tell every accession candidate something important. So free movement is legally elegant but politically combustible. And how it is communicated to the public in Ukraine, in the exercise in member states alike, matters just as much as how it transported into law. So a perfectly transposed directive, badly explained, and can still cost a country its seat at the table. No, like I'm telling it, yes, just in brackets. So now let's move on to our Ukrainian case. Why exactly it's a paradox in full? I just outlined for you the concrete figures, maybe to understand the main issue that we are facing nowadays. Except that we have in Ukrainian refugees within the EU, not even EU, Canada, Australia, the USA, UK, and so on. So basically nowadays official statistics says it's over 14 million people. So they had to flee. Who knows how many gonna come back? Nobody knows. Yes, so that is the matter of a question. So here, where does Ukraine actually stand? On one side of the ledger, the EU response to Ukrainian displacement since 2022 has been genuinely without precedent. It's a fact. The Temporary Protection Directive, dormant since 2001, activated for the very first time for us, basically. It was done for us. We all appreciate it because it just gave us a lot of benefits and opportunities to integrate into new environment, basically. And on the other side of the ledger, inside Ukraine itself, movement is administratively fractured. We have close 3.7 million internally displaced persons, people who have not crossed international border at all, who therefore fall entirely outside the EU free movement framework and largely outside a coherent domestic one too. So basically what we have, the precise gap. So the administrative legal regulation of international displacement or internal displacement is frankly underdeveloped. Registration procedures, portability of social benefits between regions, housing, location, and voting rights for internally displaced persons are still being built. And sometimes even our case law doesn't work like it should be. It's a fact. So this is the paradox I opened with. Now stated in full, Ukraine is the largest real-world beneficiary of the EU free movement machinery in generation, and a state whose own internal movement law is, in wartime, more restrictive than at almost any internal in its independent history. So any honest lecture on this subject has to hold both of these facts at once. So let me add one more dimension, because I think that it's underappreciated, even within Ukraine. The exit restriction on men of mobilization age has produced a demographic asymmetry inside the refugee and temporary protection population itself. So the large majority of Ukrainians who have exercised free movement into the EU since 2022 are women, children, and older people. So it's only basically about this category of people. So that is not a criticism, it is simply a fact with legal consequences. So it means our accession area, thinking about free movement of workers, cannot be modeled on the 2004 template of young, economically active migrants moving for opportunity. So it has to be modeled, at least for the transition period, on a population profile shaped by displacement, caregiving, responsibility, and eventual hoped for return. Within the exactly my fifth lesson today, because we're going to talk about it, about planning for return is not an afterthought, but close to the center of the whole argument. So here, what you may just read it, I will just comment, yes. So basically what we are facing here, that is a technical checklist, and Ukraine's negotiators, colleagues I engage with directly, are moving through it methodically. So since obtaining candidate status in June 2022 and opening formal accession negotiation, Ukraine has been undertaking in screening process, cluster by cluster, mapping domestic law against acquis line by line. You know that principle acquis commentary that we have to adopt just to be a member state. Yes, basically all these clusters. That is real, serious, necessary work, and it should be not under a state. So, but I want to argue that a technical checklist is the easy part. The harder part, that the part legal academics like myself have a real obligation to work on, is legal cultural. So building inside Ukrainian administrative law and inside Ukrainian judicial reasoning, the proportionality-based, individual conduct-based way of thinking about restrictions of movement that I described a moment ago. So you cannot transpose a mindset with a directive. You have to build it case by case, through training, through doctrine, through court decisions that get it right and that get cited by the next court. So that mutual recognition of qualification will actually require of us, no, it's a fact, it's not enough to sign a regulation. Ukraine will need functioning, corruption-resistant professional bodies for lawyers, doctors, engineers, architects, capable of certifying that a Ukrainian qualification meets the standard an EU counterpart will rely on without rechecking. That is the main question nowadays. So that is an institution building project measured in years, not a paragraph in a negotiated position paper. So the same is true of social security coordination. Ukrainian pension record has to be portable, legible, and trusted by a German or Polish social security office. No, like for instance, and none of that is a glamorous work. It's not about glamour at all. All of it has actual substance of the chapter. So then, I've just talked about it, sorry. Then also what we are having. Those 5 lessons that I want to talk about, I hope so that I manage it on time. So let me turn to these lessons. And the part I hope is genuinely useful to you beyond the legal history, because maybe it's something brand new that you just do not know, or maybe you weren't informed so much, because different resources, I understand that, and quality of them, also it's a matter of question. So like the first lesson, it's the sequence that reforms correctly. Every time each state has to reform something. Yes, it's also about reform, but it's not about the measuring of its effectiveness. We every time reforming something, but how to measure, does it just affect on any kind of institutional framework? It's difficult just to estimate. So previous enlargement rounds showed that free movement works best when it arrives after, not before. A candidate state has built functional domestic administrative capacity to handle mobility, like registration system, portable benefits, digital identity. So Ukraine's IDP crisis, it's basically in strange way a live pilot project for exactly this capacity. So every gap we force to close for our own displaced citizens today is capacity that we will need for EU-wide free movement tomorrow. So it's not a silver lining I offer lightly, but it is true, and it means our IDP legal reforms are not a side project. They are accession preparation, whether we label them that way or not. The second lesson, so in 2004 and 2007, several existing member states imposed transitional restrictions, in some cases up to 7 years, on free movement of workers from new members. We have like some kind of Polish plumber anxiety that it became known in France. Ukraine, with a population larger than any 2004 accession state and a wartime economic and demographic profile, unlike any previous candidate, should expect this conversation not to be blindsided by it. So the lesson is not to fear transitional agreements. They are a normal, legally sound tool in this case. Then the third lesson, like I've told every time, it's about constitutional institutional capacity. So courts, migration services, then border agencies, they will one day apply EU standard tests to restrictions on movement need to practice that reasoning now. So on our own martial law derogations, on our own IDP cases. So every judicial decision that reviews both time, individualized and time limited is training exactly the institutional muscle Ukraine will need under EU law. Then the fourth, it's that EU has never before had to build free movement doctrine for a member state actively at war on its own. It's true. On its own soil, exactly. So Ukraine's experience with crisis derogation, temporary protection at true scale, and disciplined judicial review or wartime restriction will hand the Union real material for its own next crisis. I say this not to flatter my own country's position, but because accession negotiations go better psychologically and substantively. So when the candidate state understand it is also a contributor to the doctrine, not merely a recipient of it. And the last one lesson is planned for return, not for departure. Maybe you heard that a couple of EU member states want us to return. Basically, it's Germany. Nowadays, it's Poland. Nobody knows it's about a propaganda or a hate speech, as we all know, because we are, yes, legally educated. But still, it is a fact. And free movement law has historically been built around people living. Work is moving toward opportunity. But Ukraine post-war reality will demand the opposite emphasis. So legal administrative frameworks that make it easy, dignified, and economically rational for displaced Ukrainians. For millions on the temporary protection abroad, the EU acquis question at all. And basically, they have to go home. It is an Ukrainian legal policy question we need to start answering now. Recognition of schooling, work experience gate abroad, housing, land, restitution mechanisms, psychological administrative support for integrators, and also work experience and even high-end returnees. If we wait until the war ends, employer, so then what? Incentives for hiring returnees. So then the goal is that once free movement is fully achieved, it is something our own citizens choose to use in both directions, not a one-way valve that quietly completes the depopulation the war began. Taken together, these 5 lessons share a common thread. None of them can be outsourced to Brussels, and none of them can wait for the accession treaty to be signed. So, as a consequence, transitional period planning, institutional capacity, basically legal contribution to doctrine, and a policy for return are all things Ukraine can. And I would argue must begin building today, years before the free movement chapter is formally closed. And let me close where I began. Freedom of movement is often discussed as a technical chapter, a checklist of directives to transpose a cluster in negotiation framework. I have to try just to convince you today that it's something else. In the end, it is a statement of trust. Trust that a state extends to its own citizens, that it will not restrict their movement without genuine, individualized, temporary justification, and trust that neighboring states extend to each other, that opening a border will not be abused. So, thank you. I managed to do it. Maybe there are some questions, who knows?
Thank you very much for your presentation. This topic is really serious one, and
Yes.
it requires a lot of work. So maybe you have a draft works about this also, and maybe we continue to talk about this topic in November if you will have time, or in December when winter
Yeah.
comes. Yeah,
I can, because then I just want to interrupt you for a sec. A couple of days ago, we have drafted a brand new law about IDPs. So yeah, a lot of stuff just is going on. So I can share with you our experience.
Okay, thank you very much. And maybe dear participants wants to ask something, you may ask Tatiana, our professor, if you have any questions.
So everything is clear, I suppose.
They are just shocked a little bit.
Maybe much information. Totally
Okay.
agree.
So I will record this webinar and share it approximately in 10 work days because
Okay.
okay, so thank you very much. Then we will
Thank
be
you.
in touch. Have a
Yeah.
wonderful evening.
You too.
Thank
Thank you
you
for
very much.
having me. Bye bye.
Bye bye.